Unfortunately, it's completely illegal. There is no exemption to the Misuse of Drugs Act 1971, which is the act that determines illegal activities around drugs. In terms of medicinal use, many people will be aware that there were sentencing guidelines that were produced in 2011, and the guidelines outline the sentencing regime for an offence. So if someone was caught cultivating cannabis, it's likely that they would be charged with production in the first instance. The reason that they're charged with production as opposed to cultivation, and both are offences under the Misuse of Drugs Act, is because that production allows the police to go for a proceeds of crime application. So it means that they can seize assets. Cultivation doesn't allow you to do that because it's not considered a lifestyle offence under the POCA legislation. So that's the first thing that they'll be charged with. What happens when they get to court, it's not possible now to run a not guilty defence. It was tried, as many people will be aware. There was a case called R and Quayle, which was considered by the Court of Appeal, and a defence of medical necessity was put forward to the court, and the court didn't accept that. Medical necessity was being considered under almost a duress heading, which says that you can run a defence if your life is at immediate risk. In those circumstances, medicinal cannabis to reduce serious pain, it wasn't accepted by the court that that was a legitimate argument. So we now have no defence, and all of the human rights arguments have been run on this issue. So unfortunately, most people will plead guilty. It will be very hard to run a not guilty unless there is something procedurally wrong with the case. And then the sentence will very much depend on the role of the offender and the quantity of drugs that are seized, the quantity of plants that have been seized. So for sentencing, the role of the offender is considered to be the culpability test. So there's two main tests that the judge has to consider when issuing a sentence. One is culpability, role of offender, the other is harm, and that's directly linked to the quantity of drugs involved. In most cases, a medical user of cannabis who has cultivated either their own crop or has grown as a caregiver, say for example, will be considered at the lower end of the role, of the offender role. So there's three distinct categories. There's the lesser role, there's a significant role, and there's a leading role. Leading role is top of the food chain. I mean, these are the guys who are considered to be involved in organised crime. Someone who's in a significant role could be someone who, for example, grows and even sells a small amount to friends, or even shares with friends. There have been some cases where, depending on the facts of the case, they've fallen within the significant role. If you had someone who was growing cannabis for their own medical use but said that they sold it to other people who had medical problems, they potentially could be at risk of falling within that significant category. If, however, you have a defendant who says, I was growing it for my own purposes, they should fall within the definition of lesser role. So if you're in the lesser role, we're moving you down the severity of sentencing scale. The next thing the court will consider is the quantity of drugs involved. And there are four categories. Category 4, which is the least amount of drugs that will be considered, it's the lesser category again. It's up to 9 plants. It's important to note that when we're dealing with the plants, there's also a yield factor involved. So each plant is assumed to yield 40 grams. So if you have huge monstrous plants that yield a lot more than that, you may not fall within that category range, that category 4 range. Category 3 then is 28 plants. And then category 2 talks about the operation capable of producing a significant quantity for commercial use, and then category 1 is a operation that is capable of producing an industrial amount of cannabis for use. So you have these 4 categories. Now for most medical growers, we would see lesser role and quantity 4, category 4. And then there's a sentencing matrix, and that's, you have a starting point. And the starting point for the lesser role, category 4 defendant, will be a fine. But it can be anything from a conditional discharge. They'll have a starting point of a fine, but a sentencing range, which can be anything from a conditional discharge right through to a high-level community order. So that's all quite complicated. So if you want me to break that down in any more detail, I'm happy to do so.
I think, so essentially, if I'm somebody who is growing cannabis right now for medical use, and I've listened to what you said about 9 plants and the lesser role, in reality, with no real previous convictions, what is going to happen to me?
Well, you mean, in the first instance, I would really try and argue for a caution at the police station. I mean, that is possible if it's a small quantity of cannabis. The issue with that is that you are admitting guilt at the police station. So the first instance is, say you're arrested for the offence. I mean, the advice we would give is don't give any comment at interview in the first instance. Get legal representation, no comment interview. You'll be released on bail, call release. Okay, talk to us about the case, and then we'll talk through what the options are. You will then be asked to answer bail, and at this point we really try to convince the local police force to issue a caution that will prevent proceedings moving forward. It's still a criminal record, that's really important to note. If it goes to court though, and you do fall within the lesser role and the lower quantity range that I've talked about, the 9 plants, then as I said, the starting point will be a fine. And the fine is dependent on your income. You should put forward to the court your medical conditions. So medical use itself is not a mitigating factor, but if you have a serious condition, a serious illness that is either in need of urgent treatment or long-term treatment, and for many people who use for medical purposes, they will fall within the category, their condition is a mitigating factor. So that potentially pushes it away from a fine towards a conditional discharge or an absolute discharge, which again is still a criminal record, but there's no penalty involved.
So then we've been through that process, but we're still a medical patient and we still have medical need. So we still have the impetus to grow cannabis. Very unlucky and get caught again. Where am I?
Well, again, if we take it that the circumstances are the same, that you're in a lesser role and that it's 9 plants, around the 9 plant mark, the sentencing point is still the same, so still fine. The problem this time is you have an aggravated factor. You have a previous conviction. So that means the likelihood of the judge moving from the starting point of a fine down the range towards a conditional or absolute discharge is highly unlikely. They're either going to give you the fine, because they will still consider the mitigation in the circumstances, or they will move towards a community order, and that community order could be anything from meeting with a probation officer on a regular basis to drug treatment. Those would be the 2 main ones, potentially supervision orders, but that's what's likely to happen on a second occasion. Obviously, this isn't hard and fast. Each case will depend on the facts and how the prosecution presents those facts. But ultimately, we should still be within that sentencing range. On a third occasion, we are more likely to see a real risk of a custodial sentence.
What is it about the third time that changes the guidelines? You mentioned before that it's anywhere from a caution up to a fine, but if the roles are the same and the quantities are the same, what is it about it being a third occasion that changes it?
Well, as I've said, these are guidelines. So the court at any point can depart from the guidelines. And if someone is considered to be a repeat offender who is, if you like, flagrant of the law, who is intentionally breaching the law, there is a real risk that the judge will look negatively on that individual, and that they feel that they will have to send a message. And that's where the risk of a short custodial sentence is likely.